the investigation. So we already know that there are 5 steps in investigation. Then when and how investigation will be started. When and how investigation will be started, on which methods? Tell me, when investigation will be started? Normally, when investigation starts, basing on what start, when it starts. Somebody say, when investigation starts. Anybody? Yes, when investigation will be started.
When the FIR registered, investigation is start.
Yes, correct. When FIR is started, then investigation will be started. A law final year student is saying, but law practitioners are not saying. That is one method. When investigation will be started. Is there any other ways?
If a
Is
court
there,
directs the concerned police to investigate into the matter.
is under which section?
Sir, I can't remember.
Yes, if court directs, that means if magistrate directs the police, then also investigation will be started.
Started based on the complaint received from the concerned,
Okay, that is one another way. Is there any other way? Two ways you told. Any other way?
Sir, 190 subclause A, private complaint also. Section 190 subclause
190 private complaint.
Yes, sir.
Private complaint is private complaint to the magistrate. When police starts investigation, in private complaint, what happens? Okay, in private complaint filed with the magistrate. So what happens?
Police officer to investigate.
Under section 156 clause 3, if magistrate directs, that is one concept. In another concept, 155 clause 2. Section 155 clause 2, that is regarding non-cognizable offense. That is regarding non-cognizable offense. 155 clause 2. 156 clause 3, regarding private complaint and the cognizable offenses directed by the magistrate. And the last method is sumoto. Sumoto also, I already told you. If you see section 157, it is written as otherwise. If from information received or otherwise means sumoto. Here the sumoto also they can take admission. They
in
can
which
take
circumstances, sir? In which circumstances sumoto?
What is that?
సుమోటో అని ఎప్పుడు తీసుకుంటారు సార్?
Information received. If there is any information to suspect the commission of an offense.
Okay.
As a reason to suspect. Okay.
Okay, sir.
That is. So these are the 4 methods to start the investigation. These are the starting ways. Next, already there are 5 steps. We know that. And come to investigation principles. Already we discussed 173(2) and other things. Can magistrate supervise investigation? Can stop the investigation? That is the question. But magistrate cannot stop the investigation. It can be done only by High Court by issuing mandamus under 226. Once a police officer conducting investigation, magistrate cannot direct, or even magistrate cannot direct the investigation officer to direct in this way or that way, this way. If there is anything, accused has to file protest petition. If any wrong is there in investigation, accused has to file protest petition. But stopping of investigation or transferring of investigation from one agency to other agency, all other things, it can be done by High Court under 226. The basic thing what we have to understand is fair investigation is a right of fair investigation come under the doctrine of Article 14. That means doctrine of equality. That means every citizen is entitled to get fair investigation. What is the meaning of fair investigation? Investigation should be done accordance with the provisions of the law. Fair investigation. Normally what happens? This is the allegation that the police get influence from outside and they may not proceed against the real culprits. They may hide, they may remove the names of the influenced persons. They may add unrelated persons into the FIR to save the real culprits. So there are so many allegations. In such case, the victim can approach the higher authorities as well as High Court. So he has to produce the evidence available with him and can ask the High Court to direct the police to conduct investigation by taking that evidence and other things. So Ajija Begum versus Maharashtra State in 2012, the court held that citizens are entitled to get fair investigation on the complaint given by them. They are entitled. It is a concept of Article 14 and rule of law. So this is the proposition held by Supreme Court in Ajij Begum versus case.
Sir, reported in, sir.
Reported in 2012 to ALT. Nowadays, there is no such citation, need of citation. If you type the name of the petitioner in proper way, immediately it will come in Indian Kanun or Google.
Okay, sir.
Ajij Begum. Okay. So it is concept of Article 14. Next. if investigation is, as I told now, if investigation not accordance with law, then what is the remedy? The remedy is, yes, tell me, what is the remedy if investigation not going in a proper way? The one already I covered. One procedure is by filing protest petition. That means suppose if investigation officer left some of the evidence and is not considering some of the evidence given by the complainant or informant, then what is the remedy? We can file protest petition with available evidence before magistrate. That is one. The other thing is by way of private complaint. The other thing, private complaint under section 200. The other thing is filing of writ petition in High Court. So these are the three ways. Okay.
ప్రొటెస్ట్ పిటిషన్ ఎక్కడ ఫైల్ చేస్తారు సార్ అండ్ సెక్షన్ ఆఫ్ లాస్ సార్?
There is no separate section of law protest petition. Protest petition will be filed before magistrate. It can be treated as only under section 200 private complaint. There is no separate provision.
ఓకే సార్.
Next, these are the some of the investigation principles. And other thing is removal of names in the from the FIR. Can police remove the names from
Yes, sir.
FIR given by the complainant? Once after registering FIR with mentioning some of the names, during the course of investigation, if police find that there is no evidence against some of the accused, they can remove the names by saying that no evidence is found against some of the accused and evidence is found against so and so accused. But they have to mention the reasons why they are removing the names of the some of the accused. And they have to take permission from the higher authorities. So these are the principles.
Under
They have the
section,
power.
sir? Under which
There is
section,
no
sir?
section. That is the power of the police officer during the investigation.
Okay, okay.
Okay. Okay. Now come to principles regarding FIR. FIR also we have discussed some of the principles. Let me know whether FIR is public document or not. Whether FIR is public document or not.
Yes, sir.
Yes, FIR is public document. Next, credibility of the FIR. If the FIR has been registered immediately after the occurrence of the offense, it has some credibility. That means value. Suppose if there is any lot of delay without any explanation, without any satisfactory explanation, it is not having much value. Suppose if there is any satisfactory explanation for the delay, then it can be taken into consideration. So basing on the explanation, basing on the delay, basing on the fact and circumstances of the case, that credibility will come. Okay. This is about some of the principles which we did not cover last time. Now come to what do you call 161 principles. Already I covered about the 160 interrogation and their meaning and their limitation, and thereafter 161 examination of the witness and other things. Now we go into the principles of those 160, 161, 162, and the power. What is the concept of section 163? And okay, come to 161. Yes, let me know what is the evidentiary value of 161, how it will be useful. And other thing before that, let me know whether accused is bound to answer for all the questions asked by police. My question is that for all questions, that means 161 is examination of the witness. I already told that accused person also come under the definition of witness. If it is so, accused person is bound. Accused person is liable to say all the answers. You know, not giving answers to the police investigation officer is an offense under section 179 of CPC. If you want, you check it. 179 of CRPC, if deliberately the witness does not give answers, it is a punishable. If it is a false evidence, it is also punishable. 173. So of IPC. So if in that situation, is accused person having any exception for not giving answer to the IO investigation? Can anybody say? Can anybody say? Newly joined Tejaswini.
Sir, good morning, sir.
Good morning. Is accused liable to give all answers to the investigation officer?
No,
Or
sir.
any exemption?
He can remain silent.
Yes, under which section?
Sir, I couldn't remember the section.
Okay, there is no section. It is only article. It is only the power derived from Constitution of India 20 class 3.
Okay.
It is Constitution of India 20 class 3. He can remain silent to the questions which are in the nature of incriminating, not for all questions. If he gives answer to a particular question, it will lead to incrimination of himself, he may remain silent. That is his power. That is his right. So that is important point to mention here. Okay, these 161 statements has to be given to the accused free of cost under before commencement of the trial. I already discussed.
207, sir.
What is the section?
207 CRPC.
Yes, 207 CRPC. Okay, only basing on these 161 statements, normally charge will be framed. Okay. Next, come to 162. 162 we did not discuss. And the judgment which gives the power to accused to remain silent is Nandini Satpathy case. I want to take one class regarding some of the important judgments which gives powers to the accused and which are important in the investigation part, like Nandini Satpathy case, Neelabati Behra case, and many other cases are there dealing with the rights of the accused person. So I will take separately one class during this week. May start from Monday to Friday. During this week, I will take separate one class, 2 hours, on only judgments, the important judgment of during the investigation, and what is the DNA and polygraph test, like such cases. Okay, come to 162. What is 162? Statement to
Statements.
police not to be signed, and use of statements in evidence. So how to use that statements? And that means how to use these 161 statements in evidence is also given by this section itself. 162 section itself has given. You first go through with the verbatim of the section. No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced to writing, be signed by the person making it. So it starts from the word no. So there is no need to sign by person making it. The person who is making, no need to sign. Nor shall any such statement or any record thereof, whether in police diary or otherwise, or any part of such statement or record, be used for any purpose, save as hereinafter provided at any inquiry or trial in respect of any offence under investigation at the time when such statement was made. So the second part of the section 162 clause 1 also says the evidentiary value, how the statement given to the police has to be used in trial or in inquiry, how it is to be used. So here the first part of the 161 clause 1 says that there is no need to sign. The second part says it should not be used for any purpose, for inquiry or trial, except provided herein. So there is some method is there. For limited purpose, it can be used only by the accused. Of course, thereafter, if there is any contradiction or something is there, with the permission of the court, prosecution also. So the first point is not to sign. Why this has been given? Why code itself? Why code itself has given that? 1 minute, one phone is coming, important phone. Within 1 minute, I will restart. So, why code itself explicitly prohibited? Why code explicitly prohibited? The signature on police record. Tell me, anybody? Don't sign on the statement given to the police. That is the concept of this section 162. Okay. If you don't know, you read section 163, the connection. What 163 says? No inducement to be offered. No police officer or other person in authority shall offer or make or cause to be offered or made any such inducement, threat, or promise as is mentioned in section 24 of the Indian Evidence Act. What is this? It is explicitly prohibiting inducement, threat, or promise by police officer. That means what? Police officers are prone to that. Police officers are used to. That means police. This is the prevalent situation and acknowledged by the Code of Criminal Procedure that police officers may use or already using their power for inducement or threat or promise. By giving such inducement or threats, they are obtaining signatures of the people so that they are implicating the people. So, by recognizing this fact, code itself explicitly prohibited. If there is a need to sign on the statement given to the police, police will use force to take that sign, to take that signature. With that concept, the code itself prohibited. And 163 clearly prohibiting to the police office. Don't use the power. But no police officer or other shall prevent by any caution or otherwise any person from making course of any investigation under this chapter any statement which may be deposed to make of his own free will. If any victim goes or if any witness goes, he can say it is not prohibited. What is the prohibition is? Signature. With the why it is prohibited? Only because of this fear. The police may abuse their power. With that fear only, the code itself clearly stated. Okay, now come to the evidentiary value of a statement given to the police. That is either 161 or 162. So these statements normally is having any much evidentiary value because they have been given to police. The only point here, why police statements have not much value, why the statements given to police are need not to be signed, why all these things is only with the fear of abusing of the power by the police. If evidentiary value is given to the statements given to police, what happens? Very simple. Every offense will be proved. Every person will be sent to jail. All are convictions only. So these 161 statements can be used by the accused. These 161 statements can be used by the accused for defense purpose to contradict, for contradictory purpose. Suppose 145 Indian Evidence Act provides contradictions. Normally, witness, any false witness is there, he cannot maintain conformity. He cannot maintain conformity. He may say, by the influence of the complainant, what complainant says, the witness also says in 161 statement. But when he comes to the open court, he may give different version because he is not sure. He is not real witness. He did not see what happened. So because of this controversy,
Atya.
this contradiction
Rice cooker on చేయండి.
can be used by the accused under section 145 of Indian Evidence Act. So it will be a evidentiary value. It can be used by the accused. Normally, improvisation will be there from FIR and 161 to what do you call this open court, that is evidence given in deposition given in court. They cannot maintain the similarity. 161, they may say one thing. If it comes to open court, they may say another thing. Then that can be a good ground for the accused as a defense. And also, hostile witnesses are there. Who is called hostile witness? Can anybody say?
He did not support to the case of the prosecution, sir.
Yes, he is one of the witness according to 161 statement.
Hmm.
But contradictory to that statement, he gives another version in open court.
Yes, sir.
That is called hostile. He may say, I don't know who committed the offense, but I just hear that. If it is says, it is hostile. In such a case, prosecution can use the 161 statement against him. It can conduct cross-examination.
Yes, sir.
So there it will be used for the prosecution side. So these are the evidentiary value. Statement recorded under 161 cannot be used as evidence against the accused. But there is no bar. In civil cases, it can be used. And the fundamental thing is, statements recorded under section 161 are not substantive evidence. That we have to understand. Important point. Whether it is a substantive evidence. No, it is not substantive evidence. It is only a limited purpose. Particularly in victim, that means accused, it can be utilized. Normally 161 statement also shall be recorded at early stage. At early stage. If delay is happened, it has to be explained properly. Version will be, what do you call it? The version of the witness will be changed due to running of the time, due to lapse of the time. Next. So the credibility of the witness can be shattered, can be questioned by using these 161 statements by the accused. To shatter the credibility of the witness, accused can say, he is not credible witness, Millard, Your Honor, because he is not saying one thing in FI, one thing in 161, one thing is in open court. So improvisation is there. You can say like that. Okay. These are the some of the principles of 161, 162 statements. We already read section 163. What is the prohibiting the code? What is the code prohibiting to the police officer? Here we will see the proviso mentioned in section 162. This is the same. Provided when any witness is called for the prosecution in such inquiry or trial, whose statement has been reduced in writing as aforesaid, any part of his statement, if duly proved, may be used by the accused and with the permission of the court by the prosecution to contradict such witness in the manner provided by Section 145 of Indian Evidence Act. So this is important. And when any part of such statement is so used, any part thereof may also be used in the re-examination of such witness. So once it is used in evidence, re-examination also can be done. But for the purpose of only explaining any matter referred to in his cross-examination. So when this section has been, when this evidence has been used for the purpose of cross-examination, the same can be used re-examination also. In re-examination also. Okay, this is the concept. It is not come under the section 32, 27 of the Act. That is different concept. I will explain. We will discuss it later. So this is 161 and 162 and 163. Next section is 164 confession statement. This is very important statement. Without there being any question on confession, either in preliminary and mains, no question paper, no criminal question paper will be there. So we will take separate class exclusively for confession. We have to, at least it takes 2-3 hours. We have to come from substantive provisions of confession from Indian Evidence Act, and thereafter criminal rules of practice and 164. So we have to cover 3 acts. Of course, criminal rules of practice is part of CRPC, but Indian Evidence Act. Altogether, मिलकर discuss करना पड़ेगा. Okay, that is 164. Come to now, because now time is there, we will discuss the concept of arrest. Chapter 4. Chapter 5, arrest of persons. Okay. So this is also part of investigation. This is also part of investigation, particularly in Andhra, Telangana. Now this concept is being discussed everywhere in TV. Is it not? What is the powers of the police to arrest? And if the arrest is has been made, what is the procedure? What is the after arrest procedure, medical examination, and all these things? Okay. We start with the section 41. You may hear popularly about 41A notice, but we discuss start from 41. The arrest of persons, chapter 5, contains section 41 to 60A. Up to 60A. It deals with every aspect of the arrest of an accused. The first section is when police may arrest without warrant. This is the power of the police to arrest an accused without warrant. Okay. So this power is important, which is being alleged that this power is being abused by the police since the concept of police has been emerged. You take any report of the police commissions, they say that 60% of the arrests are unnecessary, are only for the corruption purpose, abusing purpose. These arrests are being made. That's why a lot of amendments, lot of reforms have been occurred during the course of the time to this power of arrest. That's why 41A has come. That's why Arnesh Kumar judgment has come. That's why DK Basu case has come. That's why amendments have been carried out. So we come one by one. First, we see the power of the police. Then we see the limitations on the power of the police. Okay, what is the power of the police? According to this section, regarding any cognizable offense, he has power to arrest. Any police officer may, without an order from magistrate and without a warrant, arrest any person. Here, any person. Now, the section 41 is contained number of subclasses. Of course, subclasses means it is having two subclasses, but within that one class, another provisos are there. You see, now we are dealing with 41(1). That means 41 class 1. Subdivisions are there. 41 class 1 A says that when any person can be arrested without warrant or without order from magistrate, who commits in the presence of police officer a cognizable offense. So in the presence of a police officer. So two conditions are there. Number one, cognizable offense. It should be cognizable offense and it should be committed the presence of the police officer. Then automatically he can arrest. This is the power. Next, B, against whom a reasonable complaint has been made. A reasonable complaint. These wordings are important. You also mentioned these wordings calculately, perfectly. Because Bail Act is important while taking competitive exams in judicial side. You have to mention the language given in the Bail Act. Technical words should not be missed. So reasonable complaint has been made. That is one condition. The other condition is credible information has been received. So here reasonable complaint has been made means somebody will give complaint. But here credible information has been received. You only received information. It may be anonymous, it may be telephonically, it may be PCR call, it may be any other way of source, but it should be reasonable. Reasonable suspicion exists. Credible information, reasonable suspicion. He is having police officer. He is doing his investigation duty from several years. He has some suspicious about some accused. So that suspicion must be reasonable. The word reasonable carrying very value. Just because he is accused in one another previous offense, we cannot say that I have a reasonable suspicion. That suspiciousness should be adjective, should be carried out by reasonableness. That he has committed a cognizable offense. So here, the second condition is cognizable offense. Even if he is having any reasonable suspicions against a person, again saying that he may be committed a non-cognizable offense, then he has no power. If it is a cognizable offense, that too. Here two situations have been dealt by this section 41. 41B and 41BA. 41B deals with the offenses punishable with 7 years or below 7 years. Suppose if any reasonable, suspicious or credible information is there against a person, it is also a cognizable offense. Of course, it is a cognizable offense, but it is punishable with 7 years or below 7 years. Then what is the duty of the police officer is different. And the duty of the police officer is different if that offense is only, if that offense is punishable with 10 years or more than 7 years or life or death, whatever it may be. So two categories have been provided by section 41 of CRPC. One category is below 7 years punishment, another category is more than 7 years punishment. So below 7 years punishment offenses can be dealt with in another way. How that way is described in 41B. So if that is an offense, cognizable offense, imprisonment for a less than 7 years, or which may extend to 7 years, whether with or without fine, then what is the, when the arrest may be done? The following condition should be satisfied. The entire case law is only on this section. Now, the practice is, the entire criminal practice is on this section now. You are also witnessing in TVs in Andhra, Telangana. So, conditions should be satisfied. What are those conditions? Number one, the police officer has a reason to believe on the basis of such complaint information of suspicion that such person has committed the said offense. So here, the police officer should have reason to believe. Yes, sir, he has committed that offense. I got belief. You should not have any blind belief. That belief should be followed by a reason. If there is a reason to believe, if that is there, that is one condition. The another condition is such arrest is necessary. Yes, he committed offense. You have reason to believe. Even that also is not entitled a police officer to arrest an accused. If he is committed the offense punishable with less than 7 years or extend to 7 years. Then what is the other conditions required? To prevent such person from committing any further offense. So, to prevent such person from committing any such further offense, his arrest is necessary. So that I have arrested him. He has to say that, yes, I arrested because of these are the reasons. Nowadays, police officer has to give reasons to arrest of a person. Earlier, this situation is not there. Earlier, indiscriminating arrest power has been given to police. He used to arrest and kept him in one police station. He even did not give information to the family members. He did not give information to any friend. Even he did not give information where he was kept. Simply he arrest and take away. The all family members will suffer. Now the reforms have been come. That's why to prevent such person from committing further offense, he has been arrested. That is one reason. Another reason is for proper investigation of the offense. So for the purpose of proper investigation, I have arrested him. To prevent such person from causing the evidence of the offense to disappear or tampering with such evidence in any manner. So to prevent tampering of evidence, to prevent disappearance of evidence in any manner. So to prevent such person from making any inducement, threat or promise to any person acquainted with the facts of the case so as to dissuade means discourage. Dissuade him from disclosing such facts to the court or to the police officer. If he is on the bail, if he is an at large, he may influence the witness, he may induce, he may threat, he may promise to discourage him, any person, to not to reveal facts of the case to police officer. And as unless such person is arrested, his presence in the court whenever required cannot be ensured. This is also we already discussed regarding concept of fair trial. If we left him, he may not be available again. If he may left to any foreign country, or he may left to he may hide himself. So that is the another situation warranting the arrest of the accused. So I arrested him. That the reasons has to be explained by the police officer while making arrest of an accused in offences punishable with less than 7 years. So the police officer shall record while making such arrest his reasons in writing. Already I told. He should write. Okay. Normally, the reasons for not making arrest also should be written. If the arrest is carried, reasons also recorded. If no arrest is done, entire investigation has been completed, charge sheet filed, then if he is not arrested, he has to say so and so reason, I have not arrested him. So this is another. So come to next part, above 7 years. Suppose above 7 years punishment of punishable offences, cognizable offences is committed, then he can arrest. There is no such a conditions as mentioned in the above section. Now, regarding the above B, 41B, Arnesh Kumar case will come. You know that Arnesh Kumar case. So everyone should follow the provisions of 41B. What is happening? Police are repeatedly using these reasons, what we have mentioned now. These prevent such person, a proper investigation, prevent from making inducement, or are copying and pasting in the arrest memo by saying that all these, because of all these reasons, I have arrested him. So that is wrong. That is held by Supreme Court in Arnesh Kumar case that this is wrong. You cannot copy and paste the reasons mentioned in 41B and extract the same and mention in your arrest procedure, arrest memo. The reasons you should not extract like that. There should be evidence, particularly documentary evidence. There should be material to show that these are the reasons to arrest him. If there is no material, there is no prima facie case, there is no documentary evidence, there is no evidence to show that these are the reasons for arresting him. Simply you extract the 41B, then you are liable for punishment. So that what court says, if that is happened, the Arnesh Kumar judgment directed the magistrate also, don't take such remands. Don't take remand of the such accused. You satisfy yourself whether there is any prima facie case is there or not. Okay, this is the concept of 41B. We will discuss tomorrow. We continue tomorrow. Okay.